This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about what happens when an insured attempts to get a court to interpret a policy to give him coverage that he refused or did not purchase. And when an insured refuses to pay the additional premium for assault and battery coverage, he finds out that he has no coverage. In Golden Bear Insurance Company versus the Levee Bar and Grill, LLC, the United States District Court for the Western District of Missouri on November 7, 2025, resolved the problems when a bar was sued because of assault and battery by an intoxicated patron and sought defense and indemnity from its insurer, Golden Bear. GB denied the claim because its policy contained an assault and battery exclusion. On or about an unspecified date in 2024, Defendant Adrian Hubbard, a patron at the Levee, became intoxicated after being overserved alcohol. He was removed from the bar without incident, but later engaged in a brief altercation outside, bumping a female security guard. An unknown employee of the Levee, perceiving a threat to himself or the guard, struck Hubbard in the head, causing him to fall and strike his head on the pavement, resulting in injuries. Hubbard filed suit against the Levee and John Doe in Jackson County, Missouri Circuit Court, alleging negligent overservice of alcohol and removal. An amended petition filed October 3, 2024, added claims of negligent supervision, training of John Doe, who allegedly had a proclivity for excessive force, which the Levee condoned, and 2, negligence in John Doe's use of unreasonable force while acting within the scope of employment. The Levee tendered the claim to GB Insurance, and again, after amendment, GB Insurance denied coverage both times, citing the exclusion. Plaintiff Golden Bear Insurance Company issued a commercial general liability to the defendant, the Levee Bar Grill, for the period January 2023 to 2024. The policy included an assault and battery exclusion that bars coverage for bodily injury arising from enumerated acts, allegations, or causes of action, including assault and battery. It contains a separation of insured's provision, treating coverage for each insured separately as if they were the sole insured. GB filed this federal declaratory judgment action under 28 U.S.C. Section 2201, seeking a declaration of no duty to defend or indemnify the Levee in the underlying lawsuit due to the exclusion. The court stayed the underlying action pending resolution. GB Insurance moved for judgment on the pleadings. The issues facing the court were: 1, does the exclusion preclude coverage for the underlying claims? And 2, is the exclusion void as against Missouri public policy, which favors self-defense? To succeed on a motion to dismiss, the movement must show no material factual issues remain. An entitlement to judgment is a matter of law. Defendant did not contest GB Insurance's argument that the exclusion barred coverage for the underlying tort claims, negligent supervision, training, and negligence arising from alleged assault. This fact alone constitutes a waiver of any argument that coverage applied. Defendants argue the exclusion violated Missouri's policy favoring self-defense, citing a carve-out for reasonable force to protect persons or property, entitling coverage for John Doe's alleged defensive act. The court rejected this as borderline frivolous and unsupported by case law. Self-defense is a valid criminal or civil defense insulating one from liability, but it does not mandate insurance coverage for intentionally excluded conduct. These are totally separate issues. Missouri courts will not rewrite policies to create unagreed coverage. The levee could have purchased optional assault and battery coverage at extra premium, but did not. Enforcing the exclusion holds freedom of contract and is not against public policy. Therefore, the motion was granted. GB Insurance had no duty to defend or indemnify the levee or insured in the underlying lawsuit because the exclusion applies without any material factual dispute. The court declared the exclusion applied and absolved GB Insurance of its defense obligations. In my opinion, insurance policies limit the risks that the insurer is willing to take. When insuring a bar, insurers are usually concerned with the liability of the bar for injuries to third parties due to the intoxication of patrons and the actions of staff to quell disputes between intoxicated patrons. GB offered the insured coverage for assault and battery, but at a higher premium than the coverage with the exclusion. And the insured rejected that offer and opted for the policy with the exclusion and took its chances. When sued, the bar attempted to change the policy wording to obtain coverage for which they did not pay a premium, only to find itself responsible individually for the costs of defense and indemnity. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll also gain access to the more than 5,200 blog postings. Please tell your friends and colleagues about this blog and the videos, and let them subscribe to the blog and the videos on YouTube.com. And if you're interested in further detail about insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publications. Thank you for your attention.